two at a time. And I'd like you to speak into the mic. You'll have 3 minutes to testify. When you hear the beeping noise, that means your time is up, and we'd like you to conclude your remarks. Okay, I think most of you are old hands at this. Linda Saunders and Amaruk Wise, if you would come forward, please. Okay, Ms. Saunders.
Madam Chair and Commission, for the opportunity to comment again on this issue with you. And for those of you who haven't seen me up here yet, my name is Linda Saunders. I'm the Director of Conservation at Wolf Haven International. I've had over 30 years of experience working with wildlife issues in the western United States with the federal government. And I'm also a person who raises livestock and other animals in a rural setting. I have for the last 25 years. I have to protect them often from predators, which include large domestic dogs, in my case, on a daily basis. I'm primarily focusing my comments today on the proposed amendments to WAC 232-36030 and the new proposal 052. Washington has had a science-based wolf conservation management plan in place for over a year and a half, and one of the stated purposes of the amendments is to more closely align the wildlife conflict rules with that wolf plan. And this was accomplished on several occasions with this exercise, but there are some that deviate from the intent of the plan. And Dave alluded to this a little bit. The plan includes definitions and careful wording, including what constitutes an attack by wolves. The definition for attack in the plan is biting, wounding, or killing. And this definition clearly describes animal-to-animal contact. The proposed amendment definition for attack leaves far too much up for interpretation, making the decision of whether an attack has occurred highly subjective. Using the amendment definition for attack, what could be considered an attack by one person may be interpreted by another based on experience or comfort level as a wolf nearby. Another example is the proposed new section, the 232-36052. This new section includes language allowing killing wolves that are attacking or may attack domestic animals. The adopted wolf plan purposely did not allow for permitless, caught-in-the-act wolf killing because in the early stages of wolf recovery it simply isn't appropriate. The plan even discusses the risk of domestic dogs unattended in known wolf territories and includes recommendations on how to prevent wolf-dog conflicts. And again, the plan has clearly laid out a path to wolf recovery in Washington and emphasized prevention of conflict to enable people to learn how to live with wolves on our landscape, which is something new to most citizens here in Washington. The plan emphasizes that killing wolves should be a last resort in the early stages of wolf recovery. And the proposed new section does not support our wolf plan. Finally, it's disturbing that the proposed amendments in the new section to the existing interaction rules increase the opportunity to kill wolves, particularly when our plan clearly addresses lethal control and the issues were discussed and settled on after 4 years and hours of stakeholder involvement.
Thank you.
Thank you, Madam Chair, members of the Commission. My name is Amaruk Weiss. I'm going to give a little bit of introduction of myself also, since I've not had the opportunity to meet each of you, nor you myself. I'm a biologist and a former attorney. I work for the Center for Biological Diversity as their West Coast wolf organizer, and I've been working in wolf conservation for the last 17 years. Like Linda, I also have experience in having lived in rural areas. My husband and I have lived in rural and wildlands areas of Oregon and California for the last 20 to 30 years with horses, dogs, and other animals. Our neighbors have been cattle, sheep, goats, and also other horses and donkeys, but also wild animals like bears, cougars, mountain lions, bobcats, even scorpions when we lived in Southern California, and rattlesnakes. So no stranger to the concept of what it's like to live in a wild place with domestic animals, worry about protecting them, and needing to take those safeguards. But also, on another note, no stranger also to the wolf planning process. I was on the stakeholder representative group that developed the Oregon Plan in 2003 through 2005 and the follow-up legislative process. I was an advisor to a graduate student who did a public survey in Washington that then became part of the Washington Wolf Plan, and I'm now part of the California process. So my remarks here are in part really directed to this question about public opportunity to understand this commonplace period was taking place, because there has been some confusion. It seems to have been flown a little bit under the radar. That's kind of the perception. There wasn't really awareness among the public that there was an official comment period. So I really appreciate the opportunity to go back and revisit that. But I would just say on the wolf planning process, going back and taking apart the wolf plan on a piecemeal basis really endangers the public trust in the process, in participating in the public process. It also endangers the public trust in the agency's actions. I'm not going to elaborate much more on what Alinda has said, other than to say that we're also very concerned and oppose these changes to the definitions of attack from a very certain standard to a highly subjective one. We're very concerned about changes that allow people to kill wolves in response to attacks on domestic animals. Again, back to the pet safeguard issue. You know, the wolf plan addresses many of these concerns, and I can tell you from having sat in those stakeholder types of groups that they're very thoroughly vetted. The decisions that are made and put into word in those wolf plans aren't happenstance. People thoroughly thought about whether or not wolves should be allowed to be killed under certain circumstances, and I think that you should take the face value of the wolf plan. It's a great plan. Our organization and 7 other organizations recently petitioned the Commission to make it legally enforceable, and we really encourage you to take that path as opposed to adopting any of these proposals which greatly expand the circumstances when wolves can be killed or compensation can be paid beyond what the stakeholders agreed to. Thank you.
Hi, my name is Ruth Musgrave, Defenders of Wildlife Board since 1993. Thank you for the opportunity to comment on the wildlife interaction rules, and I in particular want to thank the staff of the department. I think they've worked incredibly hard on this project, and in good faith they've communicated with us a lot, and we very much appreciate that. Defenders is a national organization with more than 1.1 million members, and including more than 36,000 in Washington State. We are a science-based advocacy organization focused on conserving and restoring native species and their habitat. Defenders ran a wolf compensation trust fund from 1987 through 2011, paying more than $1.4 million to ranchers in the region for livestock losses due to wolves. We assist ranchers across the West with non-lethal methods to minimize livestock loss from predators. This includes range riders, fencing, livestock protection dogs, alternative grazing techniques, and other methods. We've spent more than $1 million on these proactive projects since 1999, and we operate these projects in partnership with county, state, tribal, and federal agencies, including Wildlife Services. We're even giving a national award at our banquet this year to the Department of Florida Fish and Wildlife Commission director for his work with us. Those of us representing the majority of the citizens of Washington worked in good faith with legislators, stakeholders, and the department last session to find a compromise that would protect the local folks who may encounter wolves, and that would also allow recovery of these state and federally listed species that have wandered into our state. What we accomplished was an incredibly delicate compromise. We compromised on the term commercial for livestock. We compromised on adding domestic animals. We compromised on allowing the new provision to cover public as well as private lands. We actively supported funding for compensation to ranchers for non-lethal methods in Senate Bill 5193, with one of the broadest compensation plans in the nation. And we supported the bipartisan letter by the state legislators that requested an emergency rule to allow the killing of one wolf without a permit if the wolf was, and I quote, discovered in the act of attacking livestock. Further, the bipartisan letter referred to allowing private individuals, quote, to protect domestic animals against an actively attacking wolf. The new rule stated that if the wolf is attacking domestic animals, one wolf may be killed without a permit. But now the new proposed definition of attack is that an animal contact has occurred or is imminent and includes an animal that is in attack posture or mode. Did all the legislators who signed that letter agree to that? I think they did not. Did we agree to that? We definitely did not. This is similar to Senate Bill 5187, which we actively opposed. The new definition of attack is so broad that this delicate bipartisan compromise is unraveling. Trust is an important part of compromise, and without compromise, it is empty. The department has not followed the definitions of attack used in Idaho or Montana. Excuse me. I have reviewed those, and they are not as broad as the definition you're proposing. Thank you very much.
Thank you.